Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are going to look on how to answer problem question basically. More so in the love contracts and the criminal law basically. Realize that under those questions they bring questions of problem one questions. So today we are going to look on how to answer problem question. If a problem question comes to your side, how are you, which criteria are you supposed to follow so that you can answer that what that problem question. But before, subscribe to the channel, like the videos and share and comment where you feel that it is necessary. So today, when you look at the problem question that is given before you, or once you have a problem question that's given before you, remember problem question composes of facts. You get facts, those are the things that happen. Any question that comes to your side, when you realize that it is a story-like nature, and at the end they want you to identify something in those facts. Basically, that's a problem what? A problem question. You get. And the criteria of answering a problem question, we have the speculate the brief facts, the issues, the law applicable, the resolution, and your personal opinion. You understand? So basically, for you also to analyze or to deal with it, when the facts are put before you, you have to read each fact keenly. You understand? Realize that if you read the first line or the second line without identifying an issue, basically you have to reread it. Realize that each line or each two lines of a problem question or in an essay, realize that there must be any issue, a legal issue. You understand? For you to analyze it very well. So basically what I argue is that first of all, when you're analyzing those facts, they must be brief. They must be as brief as you can. They can give you a question on like 2 pages, one full page, two full pages, but to analyze for you, your facts must be like not more than 7 lines, if I'm to say. Not more than 7 lines. Because you're trying to summarize something. And summarizing something, basically, as you're reading the facts, at the end of the reading, you must know the issues that you have identified. So putting your brief facts on a paper, you must be knowing the issues that you have to raise. Never make a mistake of writing the brief facts minus getting the issue that you are going to do what to raise. Because you realize that to make those facts brief, you just write facts on the issue, on a certain issue that you are going to raise. You don't need to write every irrelevant thing. You just need to write facts that are on the issue that you are going to do what? To raise. You get, that's what I urge you. So don't make a mistake of writing facts minus identifying the what? The issues. You get. So after making your issues, your brief facts brief, you get, then you go to the next. Actually, as you are writing, you first write brief facts as a heading. You analyze the issues. Basically, though, you analyze the facts. Basically, those facts, they are normally put in one paragraph. In one paragraph. And two things that can separate them, comma or a full stop. Those are the two things that can separate your what? Your brief facts. But they must be in one paragraph. You get, so put that in mind. Then afterwards, we go to the issues. The issues, those are the issues that you have to resolve, or the issue, something that needs an answer. Basically, the issues, it is like a question that you have to answer at the end. The issue, basically, you can start whether or not, whether or not or whether. All of them, they are correct. You understand? Let me give an example under contract law. Whether there was an offer between Jerry and Walter. You get? Basically, that's the issue in contract. So when you come to criminal, you can say that whether Jerry can raise a defense of mistake of facts. You get? So that's the way that you can raise your issue. They start with whether. You get? Whether Jerry can raise a defense of insanity, whether Jerry is an abettor to the offense, whether Jerry is an aider to the commissioning of the what? Of the offense. Understand? It is whether. You start with whether or not. You can say whether or not Jerry is an abettor to the offense. Basically, note that in mind. You get? So basically, after analyzing your issues, you get your issues like that. You cannot, even in contract, you can say that whether whether the contract between Jerry and Walter was an invitation to do what? To treat. Whether the display of goods by Jerry was an invitation to treat. You get? So basically, note that in mind. That's how we raise the issues. Basically, the next step there, raising the issues, just raise the issues. You don't resolve them from there. You get? You don't resolve them from there. Then basically we go to the law applicable. The law applicable basically here, basically note in mind that this is the law that you are going to apply while resolving the issues that you have speculated above. What do I mean? Or why do I strongly say that? Never put a law applicable of which that law you are not going to use it. Regardless, however much it is applicable, but if you are not going to use it, don't put it there under your SC. You understand? For example, I'll start with contract. Under law of contract, you start with the law applicable. Contracts Act 2010 and the case law. Basically, as a year one student out there, those are the laws in contract that I believe that you can use in contract as per now. Case law, Contract Act, and case law. There's no any other law. You understand? And basically note that in mind that law you must apply it. You must use sections of the Contract Act. You must use cases under contract law. That's the law applicable. Just put it the way it is. Contract Act 2010, case law. That's enough. That's the law applicable. Then when you come to criminal basically, the law applicable, you shall use the Constitution, the 1995 Constitution, the Penal Code Act, and the case law. You get? That's as a year one student, that's where I believe that you can highlight. You understand? I don't believe that a year one scholar can apply laws more than that. You get? But those are the laws that are really worth. Don't put the Police Act. Don't use the Magistrate Court Act, the Judicature Court Act, however much you know them. But once you're not going to apply them, don't put them. Don't apply them. You get? Don't apply them because they will penalize you once they are marking your essay. You understand? Just use the law that you're going to use. The fact that I've used the Constitution, it talks about Article 28, talks about the burden of proof in criminal matters. You get? The Penal Code talks about the defenses, talks about the parties to crime, incoherent offenses. When you go to the cases, we all know that the Wilmington versus DPP is an authority. You get? Khalid, it is an authority. Khalid versus Kabalik Smoke Ball Company is an authority under contract. So that is the case law. That's why under the law applicable, case law doesn't miss. You get? Case law doesn't what? Doesn't miss. So put that in mind, or bear that in what? In mind. So after speculating your essay like that, the good examiner gives you 5 marks, 5 free marks, basically, without even going any further, saying that this and this, just stating the brief facts, the issues, and the law applicable. You have your 5 free marks. You get? So now the gist is on the resolution. The gist of the question on the resolution. But on the resolution, remember, we are resolving the issues that you raised. You get? A good essay must, actually, for you to answer, once you are answering a problem question, your issues must be not less than 3 issues. Let them be more than 3 issues, but not less than 3. You understand? For you to get the 25 marks on that particular question. So put that in mind. So when you come to the resolution, you are answering or you are resolving the issues. So we have said that whether the contract between Jerry and Walter was an invitation to treat, whether the display of goods by Jerry was an invitation to treat. Let me give an example. Let me solve the issue as an example. Whether Jerry whether the display of goods by Jerry was an invitation to treat. The procedure of solving the question or that issue. The procedure, you start with the statute, the case law, relation, and conclude. You state the statute, you state the case law, you relate, and conclude. So basically, let me have given that example. For example, the display, whether the display of goods by Jerry amounted to an invitation to treat. Basically, here you start with section 2 that defines a contract, which says that a contract is an agreement that is enforceable by law following section 10 of the Contracts Act. We define an contract which has pre-consent, consideration, among others. So there you have stated the statute. How does the statute define a contract? Then you go to the cases. Following the case, in the case of Fisher versus Bell, talks about that the display of goods does not amount to an offer other than it is what? An invitation to treat. You get, whereby in Fisher it was a knife, what and what he was violating. However, it was just inviting the public to make offers, but wasn't offering, hence wasn't reliable. Just like Jerry's act of the display of goods. So I've finished to state the case. Now I'm relating it to the facts. In the case of Fisher versus Bell, they say that the display of goods does not amount to an offer. Rather, it is an invitation to treat. After analyzing the facts, I will say that just like in the facts that we have, Jerry's display of goods cannot amount to an offer, rather than it is an invitation to treat. Therefore, Jerry's display of goods is an invitation to treat, but not an offer. I've concluded. You get? So put that in mind. We follow the statute, the case law, we relate the case law to the facts in hand, we conclude. That's the protocol or the procedure that we move on while resolving the issues. You get? Then when you go further, realize that I'll give also a sample under criminal. In criminal, basically, you may say that whether Jerry can raise a defense of mistake or facts. That's the issue that I raised. Now, in resolving, as I said, you start with the statute. You start with the statute, case law. You relate the case to the facts. You conclude. That's the procedure. So basically, here, what you have to know in mind, or as you are resolving, realize that whether Jerry can raise the defense of mistake or facts. We shall start that Section 9 of the Penal Code Act provides that provides for the defense of what? Mistake of facts. You understand? Provides for the defense of mistake of facts, whereby someone can be acquitted on those grounds once he proves that he did it in an honest manner, in misbelief of the reality or the truth. So realize that it is a complete what? A complete defense. Then you say that just like it was stated in the case of Ara versus Sultan Majinga, whereby the court held that Sultan Majinga had no case to answer because the throwing of a spear to the deceased was done out of mistake of facts. Just as in our facts, Jerry's killing of Walter was done under mistake of facts, in an honest belief that that Walter was what? Was a cat, basically. You understand? So therefore, we conclude, therefore, Jerry can raise a defense of mistake of facts on the above what? Grounds. We get. So let me hope we are clear and we are getting anything that is unclear, put it in the comment section so that we can answer it very well. So basically, that is some of the sample that how you can do while resolving your issues. You get. Remember to conclude every issue. Remember that, because the issue you are asking whether Jerry can raise the defense of mistake of facts. That's not a conclusion. Concluding is that you are satisfying it. You are making it clear that Jerry can raise a defense of mistake of facts. There you have concluded your issue after analyzing it or resolving it in your discussion or the way you have argued it out. You get. So basically, note that in mind. So the resolution, and also at the end, you can give your personal opinion. Understand, on certain facts. Personal opinion, I won't give it, but you as a person that has resolved the issue, do you think that court is just in deciding what you have decided above, or you have another perspective view of how you see the law. You understand? That is your personal view or personal opinion. You can either concur, support, or you can give what? A dissenting argument about the essay, about how you have argued it what? Out. You understand? That is the personal opinion. And most of the times the personal opinion is not necessary. But if you have time in a paper, you can give it just to make the one that is marking your paper more sure, and you show him that your perspective, your analytical view, you understand, your back view of the point of law. Basically, that's what you can do. Or basically, that's what you can highlight. So, other than that, that's we can answer a problem question. But other than that, thank you for watching. Subscribe to the channel. Thank you.